always encouraging when the technology decides to cooperate. But without the same time and travel constraints that the Minister has, I'm sure the material is always going to work. It's only when one's under pressure that one is a little more pressed. Look, I'm very grateful for the opportunity to be able to address you today. I realise that for a gathering such as this, having a lawyer come along is always a little challenging. But I was encouraged by the rector's comments that the humanities have a place at ADFA, and whilst they don't have a legal contingent here, it's at least makes one feel a little more welcome. What I'm going to talk to you about today are some issues and trends in ocean resources and security. My centre, the Australian National Centre for Ocean Resources and Security at Wollongong, has an interdisciplinary approach to these things, and I'll try to break away from my own discipline a little bit, but we'll be dragged back into it to perhaps talk to you about some things that you may not necessarily be as aware of as you might, that are relevant to naval operations and particularly maritime operations in the littoral. What I'm going to talk about is a little bit about issues surrounding freedom of navigation and particularly islands. This is where the legal definition of exactly how wide the littoral is can vary, and we have some recent cases that make this a little bit more complicated. I'll also talk a little bit about what the Americans describe as grey zone activities and what they involve. A little about the use of international tribunals and how this can create some issues with respect to the law of the sea. And then very briefly, a current issue that's perhaps not in relation to the close littoral, but is occupying a lot of diplomatic effort in areas beyond national jurisdiction. And finally, a little bit about issues for the protection of cables and pipelines in areas. I'll put this little clicker a little closer. You may be aware, because the media has spoken an awful lot about it, in recent times there was a case between the Philippines and China, initiated by the Philippines, with respect to the status of various features in the South China Sea. Now, this case did not discuss who owned these features. It would have been impossible for the Philippines to bring such an action under the Law of the Sea Convention. But it did allow the arbitral tribunal in that case to discuss what the status of certain features in the South China Sea were. Whether particular features were islands that would generate the full range of maritime zones, or whether they merely generated a territorial sea or at best a safety zone. Now, Australia was not a party to this litigation, but has expressed its support for the litigation going forward. What is interesting from the litigation is what the court had to say about the status of features in the South China Sea as to whether or not they would generate maritime areas. Now, this is important because the areas that a particular feature might generate will determine what rights we have to navigate in the vicinity of that feature and what operations might be able to be conducted. Now, what is interesting is that the court, in their decision, found that none of the features in the South China Sea whatsoever were capable of generating an exclusive economic zone or a extended continental shelf from their extent. At best, they would generate a 12 nautical mile territorial sea. Now, this came as something of a surprise because the largest feature in the South China Sea, one which is occupied by Taiwanese forces and has been for many, many years, is actually quite a sizable feature. And to spice up what may be a legally dominated presentation, I thought I'd show you a couple of pictures. Oops, pressed the wrong button. This is a feature that's known as Itu Arbor Island, or which the Taiwanese refer to as Taiping, and it has the obligatory runway through the middle of it. It's got some trees and the like. Apparently the Japanese back in the 1920s and 30s planted rather a lot of bananas and papaya and that sort of thing. So most of the greenery you can see there actually produces stuff you can eat. There's, as I say, a 1,200 metre runway, as well as various structures. They have about 800 personnel plonked there, and of all the places you could be placed in the South China Sea, this is one of the more pleasant ones, I suppose, being of a reasonable sort of size. They've extended it recently. They've bunged on a little bit of a harbour. Now, the island itself is one that is essentially natural. This is not one of your do-it-yourself kit islands that you take a whole lot of concrete and sand and compressed rubble and the like and start dredging and hopefully that you produce something that can survive the latest round of typhoons. This one is the real deal. It actually was there before, and it's been regarded by most as an island. It is 46 hectares in area, 600 to 800 personnel, the numbers vary. They've recently installed a photovoltaic power station so they can do this, and they've invested heavily in battery technology, whether that's from Mr. Musk or not, I'm not entirely sure, but they've got batteries, and they claim to be able to produce enough fresh water to produce 65 metric tonnes of fresh water every day, as well as growing their own fruit. They've been very keen to boast of this because of what the court had to say about their island. Or their island, we don't have any view as from the point of the government of Australia. No, I'm not from the government of Australia, as to who owns it. Now, what's interesting is the court said this does not generate an EEZ. It is not capable of human habitation. This must come as a shock to the 600 people who are there, but it was not of sufficient size or able to generate the kind of support for human beings that would allow this area to generate the full range of maritime zones. And now for other states, this is something which presents us with a conundrum, because there are areas in the world which are not as inviting as Itu Aba Island, that are in fact substantially less inviting, and yet if we look at this nice map of Australia, we have things like Elizabeth and Middleton Reefs, or Ashmore, or Macquarie Island, or Heard Island, which Australia says generates an EEZ in each case, and yet are substantially less inviting, less suitable for human habitation, perhaps, or not meeting the definitions that the court has expounded upon. For example, Elizabeth and Middleton Reef is nowhere near 46 hectares, at least in terms of the portions of it that are above sea level, but Australia is of the view it generates an EEZ. Ashmore does have a few islands and some wells, although I'm told the wells have cholera, so it's probably not a good idea to drink from them. But you would say that that's not as nicer place for human beings to be. We also have... Daisy? We also have features like Heard Island and Macquarie Island, which would be certainly of a size that would be much larger than Itu Aba, but would struggle to meet the other portions of the definition which the court expounded. And this presents us with a problem, because on the one hand, our government has supported the decision and said that all parties should abide by it, but it has messages for us that we may not like to recognise. And we're not alone. The United States has features like Johnston Atoll, which would be smaller than Itu Aba in its original form and has been substantially extended, that they say generates an EEZ. Palmyra Reef they would struggle with. Swains Island in American Samoa they would struggle with as being features that would generate the full range of zones. So the international community has lots of these features. For us, this is something which we need to consider in terms of how big our littoral is and what we can effectively claim, and whether we want to be able to go to court in relation to these areas. I should also say something of grey zone activities, and the spelling is because various American authors have written about this, and they prefer grey with an A rather than an E. This is essentially the use of civilian vessels to provide a method of putting on pressure in areas where there are maritime disputes. And it raises issues of attributability of action to a state and state responsibility for these actions. Now, I'll show you some examples. Let's see if this is going to work. Apology for the noise. This is a shot from the USNS Impeccable some years ago when she was being harassed by a rather large number of Chinese vessels. Now, these vessels are not Chinese Navy vessels, nor are they Coast Guard vessels. They're essentially fishing vessels whose operators have, for whatever reason, decided to surround a US Navy ship which had the capability to conduct surveillance operations. This is done in waters outside China's claimed territorial sea. You have things here where you can see how closely these vessels are navigating. Impeccable is not armed, but it took her 3 days to extricate herself from being surrounded by these vessels, which substantially cramped her style in terms of being able to navigate. At one point, she did deploy some of the firefighting gear on board the ship to try to discourage the Chinese vessels, which was met by basically the people on the Chinese vessels taking the opportunity to take a bath. Basically stripping off, going, yes, we very much like the shower you're giving us. Now, what presents a challenge here is that these are not the forces of a state. It's extremely likely that they've been encouraged by their flag state to behave in this way. It seems an odd thing for people to do spontaneously, but it gives one state the opportunity to put pressure in relation to an activity or a place that is disputed, but also having some degree of deniability to be able to say, well, actually, look, we're not doing this. If there'd been a response that had resulted in any attempt to forcibly remove these, then it might have been open for the Chinese to take the moral high ground and say, well, look at this, civilian vessels are here, and now they're being forcibly removed from the high seas, and use this as a matter for some criticism. Now, China likes doing this. It's been done in a range of circumstances, certainly in this context. It's also been done with respect to some of the features in the South China Sea, in respect of some of the claims that China makes there. It's also been done in the context of the East China Sea, with the dispute that China has with Japan, where civilians have appeared. And the Japanese have also not discouraged some civilians from inserting themselves into these areas out of a sense of presumably patriotic fervour. But how to respond to these individuals and how to deal with these circumstances is legally potentially fraught. It allows a dispute to be have the temperature raised, to be escalated, without necessarily the state being directly involved. And if there's a forceful response to this kind of activity, it potentially ensures that the world opinion as to what has happened and how it's happened is something a little more complicated. And this is going to be something which I think will be increasingly made use of by some states, where they feel they're confronting naval forces that potentially are a little more capable than theirs, to be able to raise the temperature and put a little bit of pressure on. You can see just how close they were getting in relation to all of this. Now, staying in the South China Sea, the South China Sea litigation also highlights another issue that potentially is going to be a challenge for navies and maritime operations in the littoral. And that's the use of litigation to try to advance political agendas. Now, the Law of the Sea Convention has a whole part devoted to dispute resolution. And this part is designed to permit states to take their disputes, to have a third party resolve those disputes for them, and to be able to go away and work together peaceably. And these have been used in a variety of contexts. To take the Minister's theme of Singapore, Singapore and Malaysia have taken a couple of disputes utilising these processes. One determined the status of Pedra Branca, which probably since the South China Sea arbitration wouldn't qualify as generating an EEZ. And also they settled out of court after initiating proceedings with respect to issues over land reclamation. So it's a way for states to help to resolve their disputes in a friendly fashion. But it's been used in recent years by states where there's a lack of cooperation to seek to bring on litigation to push a dispute. Now, the Philippines government made use of this in the context of the South China Sea. Their dispute with China was reaching a crescendo over the Philippines having forces in Scarborough Shoal and seeking to resupply these, with the Chinese sending Coast Guard and then naval forces to try to prevent this resupply. The Philippines decides instead of escalation, they'll take them to court and ultimately get an answer that says that the 9-dash line is illegal, that China can't assert an EEZ from any of the features in the South China Sea, even if it owns them. And the Philippines goes away ecstatically happy. The danger, though, is that you have states being dragged kicking and screaming into courts and having decisions made that affect the law of the sea that potentially these states don't like very much. And China is certainly the best example, but by no means the only one. The court is willing to do this even where a sovereignty dispute is in issue. In the South China Sea arbitration, the tribunal basically said, well, we don't care if there's a sovereignty dispute here. There's enough of a dispute about law of the sea matters that we will decide it, which means that states can take areas that are disputed and find a way to have them litigated, even when the other party does not wish this to take place. Now, the decision won't determine sovereignty, but it can determine issues about the sort of jurisdiction around it, which can be difficult or embarrassing for some of the parties. And the court was very happy to do this. Of greater concern, though, might be a decision that you haven't heard of because the media aren't terribly interested in it. And this was a decision of the International Tribunal for the Law of the Sea in what can be described as the advisory opinion case, which was delivered last year. Now, in this case, it held that a group of states in West Africa could ask questions about fisheries jurisdiction with respect to an area off the West African coast. Now, this was to seek what's called an advisory opinion, to ask a tribunal questions about what they think the law is, not to settle a dispute. Now, what's disturbing about this is there's nothing in the convention that supports this being able to be done whatsoever. The court decided it could do so simply if two states entered into an agreement to do so by stretching their interpretation of Article 21 of Annex 6 of the convention. This means that any two states could enter into an agreement to ask a tribunal any question about the law of the sea, which means you could have two states, for example, Indonesia and the Philippines, ask a tribunal, what do you think normal mode with respect to archipelagic sea lanes passage means? And the tribunal could say, well, we think that a submarine should navigate on the surface and show its flag in normal mode. And this would be horrifying to maritime powers with submarines that want these normal mode to mean that it's below. Any states can ask any questions, and the International Tribunal for the Law of the Sea will be happy to approach them, answer them. Now, they're not binding, but they're certainly very influential, and it has the potential of people raising issues and having a UN-sponsored tribunal actually giving its view as to what the law is. This potentially destabilises a lot of the compromise that was built into the convention to prevent exactly this sort of thing happening. But of particular concern was the statement of Judge Lucky in the decision, and yes, his name really is Judge Lucky. He basically said the convention should be viewed as a living document, and whatever was agreed back in 1982 when it was first drafted, well, it should be able to change with the times. Well, that's lovely, except international law is not good at changing with the times. It's good when states come together, reach agreement that settle issues between them, not when a group of 21 judges decide to spontaneously think that things ought to alter because they think it's a good idea. The tribunal also said it has a discretion, that it will be able to refuse being asked certain questions. But it won't refuse to answer questions unless there are compelling reasons to do so. And it took station here off the ICJ's decision in the nuclear weapons advisory opinion case back in 1996. Now, it noted that it didn't require states who were potentially engaged in disputes with the states in West Africa to even be concerned about this, because the tribunal couldn't make binding decisions. And therefore, it's just attaining enlightenment as to courses of action that might be taken. One of the judges, the French judge, Judge Cott, was of the view, however, this was a bit dangerous and it was a bit too much for him, although he did not disagree with his colleagues. He noted that perhaps they should strengthen this discretion to prevent abuse and manipulation. But the other judges did not feel so constrained, and the other 20 supported what was going on. Now, I can tell you that there are a number of groups encouraging various small states who are parties to the Law of the Sea Convention around the world who are, even as we speak, preparing to ask all sorts of awkward questions about various parts of the conventions they would like to do this. I'm aware of at least 3 environmental NGOs that are getting states to put up questions, and these questions can be posed. Now, for states, this is a concern because much of the convention has been left sufficiently vague to allow everybody to agree to it and to allow us to have enough idea that we can carry out things in the manner in which we have done for the last 25 or 30 years. This has the potential of upsetting the apple cart rather dramatically, and it's something which to date has not been fixed upon in the media or in many of the discussions because it hasn't really escaped from the realm of abstruse lawyers like myself. But I warn you that this is coming, and this will change things rather dramatically when it does. And it has the potential to tear the compromises in the Law of the Sea Convention to pieces based on what the tribunal may or may not say and what they are asked when they have the opportunity to do so. I should also mention a few other things that are happening, but are perhaps of less relevance to the close-in littoral. The largest thing that's happening in the law of the sea at the moment with respect to ocean areas is a conference being prepared to deal with areas beyond national jurisdiction. One of the things that states are being asked to contemplate now is should we protect areas of particular environmental significance in areas beyond any national jurisdiction at all. This is known as ABNJ, areas beyond national jurisdiction. Some of these areas are particularly valuable. They have ecosystems and biota which are unique because they're areas of geothermal vents at the bottom of the ocean, that sort of thing. And the UN has decided there should be an international agreement about it. So much of the effort at the moment is going into preparing for a convention to deal with this. In the last few months, there was an extensive preparatory commission established at the UN and with moves towards a conference in the near future. So this is something that you'll hear about, but in the context of the rest of our discussions today probably isn't as central as other things might be. Surely. Now I send not to know for whom the bell tolls. Hope that doesn't reflect everybody's views of how I'm going with all of this either. As a last issue, I'd like to talk about something which is a bit of a personal barrow to push for me, but is still a contemporary issue, and I'll have this running while I talk about it. Ooh, although it is rather loud. What you're going to see is a globe with a animated representation of submarine cables on it. Now, submarine cables are remarkable things. They are... Wonderful. I think that might give you a little more opportunity. Submarine cables are remarkable. To begin with, if you think they're honking great big things as big as a house going under the ocean, forget that. They're about the size of my index finger in breadth, and they look like a piece of white conduit pipe, but a little more solid than that. Inside typically are some fibre optic cables. And what they do is they provide for about 98% of the world's capacity for intercontinental telephony. If you've used the internet and you've accessed anything which doesn't have a .au at the end of it, you've made use of a submarine cable. If you've made a call overseas, you've made use of a submarine cable. At the present point in time, Australia is connected to the rest of the world by 7 of these, which means that basically 7 of my fingers is the width of what connects us to the rest of the world. These things are not difficult to find. They're marked on charts. You can easily locate them if you want to get them. And pulling them up is frightfully easy. You need a hook and a rope, and you pull them up, and a tomahawk from Bunnings can do one in without terribly much trouble at all. if you want to disrupt, all you have to do is break a cable and the music stops. If you then go another 4 or 5 miles out to sea and cut it again and drag the piece away, you can probably cut that cable off for about 6 to 7 weeks because the cable repair ships are there to repair breaks, not to replace large pieces of removed cable. Back about 10 years ago, 14 miles of cable was stolen in the Red Sea by some idiot that thought they were made out of copper and that they were in for a huge windfall. As a result, you couldn't make an easy international telephone call during that 6 weeks between Dubai and London. And various British companies nearly went broke because all their call centres that they'd relocated to India were no longer able to be contacted because all the calls had to be rerouted through the United States. Now, these cables are frightfully important, and they sit at the bottom of the ocean and everybody knows where they are. And if it only takes 7 of them to cut Australia off, and 6 of those are on the east coast within 10 miles of each other, a nice afternoon's work, somebody could cut us off from the rest of the planet, at least electronically. Which doesn't affect defence because all defence systems are rather more hardened than that and there are redundancies, everything else. But in terms of digital commerce and the like, we could all rather lose touch. And that would be rather awkward on a whole range of levels. Scarily, the international law that deals with this only limits your ability to protect within 12 nautical miles and also limits the ability to prosecute somebody for breaking a cable to the flag state of the vessel that they were on if this takes place outside of 12 nautical miles. Which means if I register a fishing vessel in Bolivia doesn't have any legislation to provide for submarine cable breakage, I can go and start pulling up cables off the bottom of the ocean for terrorist purposes, sever them, and I'm not even committing an offence, let alone having to blow myself to bits. Frankly, if I'm a bit of a scaredy-cat terrorist, this is a much nicer way to deal with things because I'm not even committing an offence to do so. And you can imagine if we all lost touch with everybody on the internet, if CNN.com and everybody else was suddenly offline for 6 or 7 weeks, let alone not being able to ring anyone abroad, this would be something of a concern. We do have national legislation. We can prosecute people out to here, which is actually contrary to international law, but we do it anyway. And the International Submarine Cable Committee has supported this legislation, so we're not likely to be sued over it. But it does give you an indication that certainly this area in the littoral is something where we do need to protect it. Is it possible to protect these cables? To be honest, I suspect it's probably not. Once you go beyond 2 or 3 miles off the coast, they are simply pieces of plastic that can be pulled up and shattered. But certainly it is something to be considered and something of great concern. I hope this is of some interest to you, and thank you very much.
We now have 10 minutes for questions. I'm reminded of the fact that cable stations have figured in our naval past, 1914 in particular. The cable and wireless crew at Goldrick Island, when the Germans came ashore from Emden, were asked to point out where the cable was, which they readily did, knowing full well that that was the dummy cable they were pointing out, and watched with some glee the efforts of the German sailors to hack pieces out of that, knowing all the time that the real one was much better hidden. But that level of vulnerability, unfortunately, only applies if you're on land. Questions? We have 10 minutes, ladies and gentlemen.
So, Stuart, is there an appreciation about the cable issue in other countries? Look, I'm sure that at some levels there are. This isn't popularly discussed, one imagines, so it's probably not a good idea to tell everybody there's vital infrastructure that's just sitting on the bottom of the ocean that can be easily located. I do know that some years ago I gave a talk about this at the Naval War College and was asked lots of questions, particularly after I showed a chart of the area off Tillamook in Oregon, where 27 cables that link the United States to Asia all come in together. And then about 2 years later, I had to do some work with ONA and was answering some questions. And a US liaison officer started asking me questions about cables spontaneously, much to the surprise of everyone else in the room. So I rather suspected somebody in the room thought I was asking questions that were of interest. Certainly, the cable companies are very concerned about it in relation to what measures need to be protected. These cables are usually privately owned, and therefore they're concerned about their assets. But I think it's more a case of if people aren't aware, then that's probably a good idea. So an audience like this one is probably fair enough that people ought to be aware, or indeed already are aware.
Stuart, my name's Michaela. I have a question regarding what you were discussing before and then how it links in with the submarine cable debate, I suppose. With regards to the laying of these submarine cables, do you think that if China or any other party in the South China Sea and some of those disputed areas started to connect then some of their islands, be it artificial or otherwise, would that have any impact on the situation in the South China Sea or have any more gravity towards their argument of recognition of territorial or EEZ areas?
Oh, look, probably not. There are quite a number of cables that go through different parts of the South China Sea. Some years ago, there was a large earthquake centred south of Kaohsiung in Taiwan, and it caused an undersea avalanche which broke over 20 cables and cut off various areas. Hong Kong had a bit of trouble getting phone calls out to the west coast of the United States for a few weeks. So no, I don't think they'll be used in that fashion. Everybody has the right to lay submarine cables in areas outside another state's territorial sea. China takes the view that they should also be paid a rent for allowing this to be done, which the Submarine Cable Committee opposes, but the operators end up paying because they want to be able to do business in China.
How much is the rent?
I couldn't tell you, to be honest, James. I honestly don't know. It's obviously not extortionate, or else they'd make other arrangements.
Hi, Stuart. Pete Dowden. Just a question about manning of ships on reefs and just, I guess, possession. Is that going to give any sort of additional legal authority to countries like, say, Philippines and China if they do man these reefs or sit on an abandoned ship for 2 or 3 years?
Look, what's critical with respect to sovereignty is demonstrating control and governance. And the easiest way to do this is to have people physically there, ideally members of your armed forces, to be able to defend the feature in the event somebody else wants to turn up. This isn't limited to places that you build yourself. There are some very unhappy Spaniards sitting off rocks off the coast of Morocco who can't leave because the Moroccans will come out and take them over because they're disputed between Spain and Morocco. There are some unhappy Frenchmen sitting in the Mozambique Channel on some very, very small features that Mozambique and Madagascar say are theirs to ensure that they don't take over occupation. So this is not unusual, and it's been going on for many, many years.
Is there a time limit then? Is it 50 years, 100 years, or it just goes on and on?
Well, I hesitate to mention it, but the UK and Argentina are still arguing about some islands that have been in dispute since the UK formally established its colony there back in the 1830s. So no, there's no time limit. This can go on indefinitely, and probably usually does.
Stuart, the advisory role of the tribunal was not foreseen. But it does seem to make a certain amount of sense that if they are the international gold standard for knowledge and legal advice, that they should be used in that way. What's the objection to that?
Well, the tribunal members are drawn from the international community. They are elected by the states' parties. There are 21 of them. They're selected on a regional basis, and there are some remarkable lawyers amongst them. But the content of the Law of the Sea Convention was the subject of long and detailed negotiation for well over a decade by a large number of states to provide for what essentially is a text that they could all live with. And indeed, some of them can't all live with it, which is why they haven't become parties. What is concerning is if the court begins to bring clarity where there was no clarity between the states, where there was no consensus. And if it does, then it runs the risk that a number of states will become very, very unhappy very quickly. I gave the example of how archipelagic sea lanes passage is perceived. States like Australia take a view that we can run submarines through, that we can conduct man overboard drills when the vessels are passing through in ASL passage, because these are part of the normal mode of the operation of the ship. And the United States takes a very strong view with respect to the deployment of carrier battle groups and aircraft in the air and submarines passing through. Indonesia doesn't like that very much, and they protest backwards and forwards over these issues. If a tribunal said, no, we can clarify this as to who's right and who's wrong, somebody is going to go away very, very unhappy and potentially say, well, now the Law of the Sea Convention does not meet our needs. Why should we stay here? Why should we put up with this? And then that runs the risk that the good things that we get from the convention, the things that are clear, are not necessarily as clear, and that states are more likely to come into conflict as to their interpretation of these things. At the moment, we have a status quo which is awkward. It's not as clear as we would like, but it's a status quo. This runs the risk of not having a status quo any longer, and that is destabilising, and destabilisation just from the legal side of the house is the last thing anybody wants. So that's the issue.
First, and then
Stuart, yeah. Talking about destabilisation, if I can go back to the tribunal ruling in the South China Sea and the Scarborough Shoals, and you mentioned that they're ruling to generate an EEZ, the island should be habitable and those particular status, and the impact that has potentially on Australia. Is there any, and of course the states and everyone else, is there any appeal process or any comeback, any way that the states or any of the countries can say, or clarify that ruling, or is that it now locked in stone?
That's it.
That's it.
That's it. Now, in theory, the decision is only binding between China and the Philippines, but the influence that it has as the first decision with respect to these issues since 1978, when the UK and France had a dispute where there was consideration of the status of Eddystone Rock, is tremendously influential, and therefore it has the potential to solidify views with respect to a variety of features. If Australia attempted to arrest a foreign fishing vessel, say 40 miles off Elizabeth and Middleton Reefs, it was almost certain that the vessel's owners would encourage their flag state to have us in the International Tribunal for the Law of the Sea saying we have no jurisdiction there because Elizabeth and Middleton Reefs don't generate an EEZ. It's almost inevitable that the ship owner would seek to have that done. So there are consequences for us, and there is no way to unwind this now that it's done.
Stuart, would you agree that this makes it even less likely that the United States will ever ratify the convention?
Look, I would agree absolutely. I think that as soon as the advisory opinion decision was handed down, any prospect that the Foreign Relations Committee would recommend to the Senate that the convention be ratified disappeared, and I think there's absolutely no prospect now that the United States will become a party. The US will take the view that the bits of the convention that it's comfortable with represent custom, which they did on the 4th of March 1983 with a statement by President Reagan at that time. That will be as far as they ever go. I don't think they can ever ratify now.
That was a comprehensive and enlightening address. Thank you very much indeed. That's a model of mine. That's all we can give you. Thank you very much indeed. And we've got